Yes.
Mr. Mattson, don't interrupt me, please.
Right,
Mr. Mattson, do not interrupt me, please.
I think the court's making a big mistake here.
Mr. Mattson?
I've never signed anything
Mr. Mattson, if you don't stop talking, I'm going to your device.
Well, I didn't want
Mr. Mattson,
Daly
stop
as my attorney. I'm a living flesh and blood man. They're trying to sentence an all caps name. It's not me. I'm a living flesh and blood man. You're after a fictional person. The only one I've ever taken an oath to is God Almighty himself. There's only one lawgiver, one creator, one judge. That's God Almighty. That's who I recognize.
And sir, you are Robert Joseph Mattson, correct?
So, I'm a living flesh and blood man, attorney for a public officer or statutory citizen judge. I'm a living flesh and blood man.
All right, you are the living flesh and blood man who's known as Robert Mattson, correct?
Attorney for Robert Joseph Mattson, which would be the all caps name. Judge, there was something that I tried to talk to my attorney about. Before you let me out of the hospital, I was in the hospital or the jail. I was experiencing a lot of pain and trouble. The jail was not treating me properly.
Welcome back, everyone. Today we're diving into one of those hearings where reality collides headfirst with fantasy. On one side, a defendant armed with sovereign buzzwords and internet legal myths. On the other, a judge who runs a tight courtroom and doesn't tolerate disruptions. This case moves fast, gets emotional, and spirals into pure chaos as the defendant refuses to follow basic procedure. Watch how every interruption makes things worse, not better. This is a masterclass in how courtroom theatrics collapse when they meet real statutes, real consequences, and a judge who means business.
After I got out of the jail, I went to the hospital, and they hurried and rushed me to Toledo Hospital, where I almost died. Had I not been released from jail when I did, I would be dead in that county jail.
All right, Mr. Mattson, we're here for your sentencing hearing today. I'm not really able to address issues of medical treatment while at the jail.
Well, I was just saying there was something I agreed to.
Mr. Mattson, don't interrupt me, please. The medical treatment that people receive at the jail is not within my purview, and I'm not going to address that today. So,
well, I'm just saying I'm going to correct my.
Mr. Mattson, do not interrupt me, please. Have you had an opportunity to read and review your pre-sentence report?
I did with the secretary for Mr. Daly.
Have you had an opportunity to discuss your pre-sentence report with Mr. Daly?
I haven't had an opportunity to discuss it with him. I did with the secretary.
My secretary got a hold of him.
Mr. Daly, if you could just let me allow him to finish his answer. What were you saying, Mr. Mattson?
I did with the secretary. I talked to her over the phone and told her everything looked good. And, I believe Mr. Daly was supposed to get back a hold of me. I don't know.
Here's where the classic sovereign script kicks in, separating the living man from the legal name on paper. Courts hear this all the time, and the response is always the same. Identity isn't philosophical, it's practical. If you were arrested, charged, and appeared in court, the system recognizes you as the same person. No magic words change that. While he's debating metaphysics, the judge is focused on sentencing. Every second spent arguing imaginary distinctions is time not spent addressing real issues like mitigation, medical records, or treatment options.
Too busy or something else happened.
All right. Thank you, Mr. Mattson. Mr. Daly, you wanted to say something on that issue.
Yes, sir. My secretary contacted him in regards to the PSI. He said everything was right. He had no complaints about anything. I still tried to contact him back, didn't get an answer.
All right. So what we'll do is have, if Mr. Daly, if you'd be willing to step out into the hallway, we have an iPad out there that we can log into the Zoom session.
But I don't think he needs that. He's ready to be sentenced, Your Honor. You have any other questions, Mr. Mattson?
Yeah, Judge.
This moment shows a big misunderstanding about courtroom authority. Judges don't control jail medical care, and sentencing hearings aren't the place to litigate hospital treatment. If there are real medical claims, they require documentation and separate legal channels. But instead of presenting records or motions, He keeps circling back to sovereign arguments. That's a missed opportunity. Sympathy matters in sentencing, but only when it's backed by evidence and presented clearly. Emotional stories without paperwork don't move the legal needle, especially when paired with constant interruptions.
And we've
I'm not
discussed it
doing any
before.
of my rights or immunities. I'm not a statutory citizen. I am sovereign. I'm not somebody who's under the
Mr. Mattson,
jurisdiction. I've never signed anything for
Mr.
the court.
Mattson, if you don't
in the
stop talking,
contract.
I'm going to mute your device. Okay? I've discussed all of these issues with you before.
Okay.
And
Well, I object, but I mean,
Mr.
you're
Mattson,
sentencing. That's what you're
all
doing.
right. I've muted Mr. Mattson's device because he won't stop interrupting me. Mr. Mattson, what I'm trying to tell you is that we have discussed these issues before. You've raised those issues. I've ruled against those issues. And ultimately, you pled guilty of your own choice to the controlled substance possession of narcotic less than 25 grams. And so I'm going to sentence you on that charge today. If you'd like, I will have Mr. Daly step into the hall and you can have a breakout session with him so you can speak with him about your pre-sentence investigation report. If you have questions or things that you want to talk with him about regarding that report. So I'm going to unmute your device now, and I want you to tell me whether you want a breakout session with Mr. Daly or not.
Hello?
Yes, we can hear you now. You want a breakout session with Mr. Daly?
Well, I've tried to talk to Mr. Daly before,
Mr.
about this.
Mattson,
And,
answer my question. Do you
yes,
want
sir.
Pay close attention here. The judge is bending over backward to protect his rights by offering time with his attorney. This is actually a safeguard for appeals. The court wants a clean record showing he had every chance to consult counsel, but he refuses to give a straight answer. That indecision hurts him. Once the judge forces the breakout anyway, it's clear the court is documenting compliance. This isn't punishment, it's procedure. Ironically, the very system he claims is unfair is actively trying to make sure he can't later claim he was denied representation.
a breakout session with Mr. Daly or not?
Your Honor, you're going to do what you're going to do. I mean, I've tried to talk to the courts and reason with the courts. I mean, if you're going to sentence me today, then I just file for an appeal. I'm an objection to anything that happens today. I was under duress when I took the plea due to my life was at stake.
Mr. Mattson, please answer my question. Do you want a breakout session with Mr. Daly or not?
Mr. Daly hasn't been much of help for me, Your Honor. So I mean,
That
the
is
court,
not an answer to my question, Mr. Mattson. Please answer the question. Do you want a breakout session with him or not?
sorry, Your Honor. It just ain't been doing me any help, no justice at all. I mean, I've already said what I had to say. If the court is going to sentence me today, then that's what they're going to do. I don't agree with anything that's going on today. I'm sorry. It's just my life was at stake when I had talked to the courts.
All right, Mr. Mattson, please stop
Yes, sir.
talking. So you refuse to answer my question about whether you want a breakout session with Mr. Daly or not. The law.
Oh, I
entitled-
didn't want
Mr.
Mr.
Mattson,
Daly
stop
as my
talking.
attorney. Yes, sir.
This is where legal mythology fully takes over. Crimes don't require a private injured party. The state enforces laws to protect public safety. Drug possession is a statutory offense, not a contract dispute. These arguments have been rejected thousands of times nationwide. Meanwhile, the judge stays focused on one thing: the pre-sentence report. That document drives outcomes. Challenging facts in it could matter. Challenging imaginary legal concepts does not. Every time he pivots back to sovereignty, he gives up another chance to influence the actual sentence.
The record, I placed Mr. Mattson on mute again because he's continually interrupting me. Mr. Mattson, what I'm trying to explain to you is that you have the right to discuss your pre-sentence report with your attorney before the sentencing. I've asked you 4, 5, maybe 6 times now whether you want to have the opportunity for that breakout session, and you won't give me a simple yes or no answer. So what I'm going to do right now is ask Mr. Daly to step into the hallway. We'll set up that iPad. I'm going to put you in a breakout session with Mr. Daly in order to make sure that I comply with with your rights to have that breakout session. So at this point, I'm going to set that up, whether you want it or not, so that we have complied with that requirement.
A few minutes later.
Judge, I just had a repeat of him from the conversation you already had. I'm prepared for sentencing.
This is the most human moment of the hearing. He talks about pain, fear, and personal loss, and that part is genuinely tragic. But even here, he can't stay on topic. Instead of focusing on remorse or rehabilitation, he returns to jurisdiction and contracts. Judges listen carefully during allocution, but they're weighing accountability and future risk. Emotional hardship matters, yet responsibility matters too. When someone mixes grief with denial of authority, it sends a mixed message. Suffering is real, but acceptance of legal reality still hasn't happened.
All right, Mr. Mattson, you've now had an opportunity to discuss the pre-sentence report with Mr. Daly. Is that correct?
No, he didn't want to hear me, Your Honor. He just told me that he was here to get me sentenced. I tried to talk to him about things. I tried to talk to him before we even went to court about things that was going on with my life and me about dying, and as far as being incarcerated in jail, which he didn't ever try to help me out, because if he would have did an investigation and known that I was in court and I was wrongfully put in jail. I told him I'm not a statutory citizen. I'm a constitutional citizen. I mean, he don't care to do anything to help me. All he cares about is just helping you guys out and get me sucked into the system, and it's wrong.
All right, for the record, I did provide Mr. Mattson with an opportunity with Mr. Daly in a breakout session. Mr. Mattson.
Yes, sir.
Satisfied with Mr. Daly and the advice that he's given you?
I'm not satisfied with the advice he's giving me, no, sir.
Do you wish to explain or challenge the accuracy or the relevancy of any of the information that's in your pre-sentence report?
The stuff that's in the pre-sentence report is directed to a statutory citizen. I'm not a statutory citizen. I'm a constitutional citizen. You cannot be a constitutional person and a statutory person at the same time, Your Honor. You have to be constitutional rights, which the court's designed to protect rights. So I was asking you, Judge, are you working as a banker or a judge today? I mean, there's nothing to show that there's even is there anything to show that there's even a contract between us? I mean, is there?
This isn't a contract issue, Mr. Mattson.
Well,
it's a criminal law
in order
issue.
for the crime to exist, Your Honor, there must be an injured party. Is there an injured party? I mean, in the constitutional rights, Share Vistas colon 481 F 945. In order for there to be
Huge break. He's avoiding prison and getting probation with treatment opportunities. That's mercy paired with accountability. But notice the warning. Compliance is everything. Drug testing, supervision, fees, and behavioral rules aren't suggestions. They're conditions. The judge is crystal clear that any violations will bring jail time, fast. Probation only works if the person accepts oversight. Given everything we've seen, the court already doubts his willingness to cooperate. This is his last real chance to stabilize his life instead of escalating deeper into the system.
That is in your pre-sentence report. So is any of that information inaccurate?
inaccurate as far as the person that the courts they're trying to sentence in all caps names. It's not me. I'm a living flesh and blood man. You're after a fictional person.
All right. So with respect to that argument, what the court will say is that I will leave the information that is in the pre-sentence report and deny what seems to be some kind of a request to modify the pre-sentence report based on an argument that doesn't state any cognizable legal theory about a difference between Mr. Mattson as a human being and Mr. Mattson as something else. So the pre-sentence report will stand.
Well, Your Honor, you never even explained to me what the jurisdiction was. I tried from the beginning to
Mr.
see what the
Mattson,
jurisdiction of the court is.
I'm going to mute Mr. Mattson again because he continues to interrupt me with a line of argument that I don't even know what to say about it. It just is It's not a legal argument at all. It is some kind of fanciful belief that there's a difference between Mr. Mattson, the human being, and Mr. Mattson as some other entity, which is not recognized by the law, and I'm not going to entertain it any further. The probation officers calculated the minimum sentencing guidelines in this case to be from 0 to 9 months. Do you agree with that computation of guidelines?
I do, Your Honor.
I do. Thank you. Before the court passes sentence, Mr. Daly, is there anything you'd like to say on behalf of Mr. Mattson?
I've had the same conversations with Mr. Mattson the court's had. He's never wanted to talk about this case. He's always wanted to talk about what he perceived are constitutional issues. He pled guilty. He knew what he was doing. I do know that.
I'd like to say on your own behalf before the court passes sentence.
Yes, sir. Can you hear me?
Is there anything you'd like to say on your own behalf?
You said that. I can say anything that I wish before sentencing.
You can.
I'm sorry, sir.
You can.
Okay. Yes, sir. Your Honor. I mean, before I took that plea, I told Mr. Daly that I wanted to sit there. I wanted him to sit there, get the cameras for the courts to prove that I was at the court date, the day that I was put in jail, and said that I wasn't in the court for a contempt of court. He said, and I told him I wanted to fight my case, but I had to be out because I had medical issues. Mr. Daly said that's fine and all, but if you stay here and you fight this case, they'll keep you in here for a year fighting the case. You will not be let out of jail. Your Honor, I couldn't do that. I was in major pain. I would have died in that jail. My proof is within the doctor's records in the hospital. I had a serious condition which would have left me dead within a week from the time that I took the plea. The following day after I got up, my wife was killed in a car accident. Just everything's been going downhill for me ever since. And now this with the courts. I don't feel that I had a fair chance with the courts ever since I even started with the courts, because the courts has not proven jurisdiction to me. I've not written any papers out agreeing in the contract saying that the courts can have any kind of jurisdiction over me. I have not relinquished any sovereign immunities that I have. I just don't feel like there's been anything fair, which is not going to be with the court system. I mean, I've tried to say I'm not a statutory person who is within your jurisdiction. If anything, I'd be considered constitutional, but I'm not even under the constitutional laws, but I will use them if I feel necessary as a constitutional living flesh and blood man. There is no injured party. The only injured party would be the state's laws, which the state cannot be the prosecutor, the injured party, and the judge. Nothing's right. The court case either had been dismissed or moved to a higher court. And I wasn't going to sit there and be left in jail to fight my case for a year. I would have been dead. I'd have been stupid not to sit there and just agree with a plea that I didn't even agree with in the first place, just to save my life. I don't think that's fair at all. It's not right. There's nothing but wrong here.